Firstly, superannuation death benefits, the payments. Upon a member's death of a member's benefits must be cashed by a lump sum or a superannuation income stream we know as a pension, and I'll call it a pension for the balance of this presentation. Death benefit pensions can be paid to a dependent beneficiary. We've previously thought about tax law beneficiaries, but we're talking about dependent beneficiaries now for the purposes of paying death benefit pensions. And those are the persons listed there who will satisfy that definition. Death benefit pensions, other than a child pension, will result in a credit to the recipient's transfer balance account. We've heard from Phil what a transfer balance account is today. And so if the recipient is in receipt of a pension and then they subsequently receive a death benefit pension, the amount of that death benefit pension will be credited to their transfer balance cap, and that could well result in them exceeding their transfer balance cap. So there needs to be planning in relation to that for understanding from clients in the next generation who may or may not be receiving pensions at a particular time and what that might mean, and we'll talk a little further about that a little later on in relation to even current pensions as well, arrangements. Therefore, death benefit pensions are only to be paid to the extent that they would not cause the recipient's transfer balance cap to be exceeded. The timing of the credit is different in different circumstances depending on whether it's a reversionary pension or a non-reversionary pension. For a reversionary pension, it is 12 months after the pension is payable to the recipient. In the case of a reversionary, that's of course 12 months after death, because that's when it will commence. In the case of a if it is not reversionary or a non-reversionary pension, the later of 1 July 17 and the time when the recipient becomes entitled to be paid the pension. That will normally be when the trustee determines to pay the pension. So we have this difference, and potentially, when on the face of it, an advantage of reversionary over non-reversionary pensions. The amount of the credit for the death benefit pension, if it's a reversionary pension, the transfer balance credit is for a pension commencing before 1 July 17, it's just before that date, and for a pension commencing on or after 1 July 17, the value on the day it commences, that usually will be upon the death of the member. If it's a non-reversionary pension, the transfer balance credit is for a pension commencing before 1 July 17, the value just before that date, and for a pension commencing on or after 1 July 17, the value when it commences. So that is the significant difference between the two, because for a non-reversionary pension, the value credited will include any accrued investment earnings on the deceased member's interest between the date of death and the commencement of the pension, which would not be the case in the case of a reversionary, and may include other amounts, for example, from the deceased member's accumulation interest, or an amount paid under a life insurance policy held in the superannuation fund on the life of the member and which is to be paid out as a pension. The credit of the value of a reversionary pension to the recipient's transfer balance account not occurring until 12 months after the member's death, I'm just recapping and the conclusions out of this, and the amount of the credit being the value on the death of the member. From a planning perspective, reversionary pensions will generally be preferred over non-reversionary pensions. To recap, for a non-reversionary pension, the amount credited to the recipient's transfer balance account is the value on the death of the member plus any earnings to the date of commencement of the pension. Let's look at an example. And this is from one of the Law Companion guidelines that have been issued by the drafts. We've only got them in draft because it's too close to the legislation being finalised, that have been released in the last 6 or 8 weeks, but the most recent one I think was about 2 weeks ago. So LCG 2017 D3, this example's from that. So Theodore commenced pension on 1 October 17, Theodore passed away on 1 January 18, the value of Theodore's superannuation interest on 1 January 18 was $1 million. Valerie, Theodore's wife, is a reversionary, and the starting day of the reversionary pension is 1 January 18, Theodore's date of death. A transfer balance credit arises to Valerie's transfer balance account on 1 January 2019, 12 months after Theodore's death. The transfer balance credit is equal to the value of the superannuation interest on the starting day, that's 18 January 18, of $1 million, and not the value when the credit arises on 1 January 19. If in the example on the previous slide, Valerie's superannuation interest was a non-reversionary pension, the transfer balance credit to her transfer balance account would be the value of the pension when the pension commences, that most usually being the date when the trustee of the superannuation fund determines that the pension is to commence. So let's look at what the ATO has to say about all this, again from the same Law Companion guideline. And the precursor to this, and why I'm just going to emphasise this, is that the Tax Office, for those of you who have any dealings with the Tax Office in relation to disputes, things that we regarded 4 or 5 years ago as standard structuring, the Tax Office are let's say, assertively, I could be guilty of using the word aggressively, in some cases, taking a position that is not inconsistent with the law. And they have demonstrated very clearly a much greater willingness to potentially seek to apply Part 4A to a particular arrangement. So let's take you to paragraph 12 of the LCG 2017 D3. The reason for the 12-month delay, and in square brackets, they're square brackets that those words I've included, in the transfer balance credit in the case of reversionary pensions, is to give the reversionary beneficiary sufficient time to adjust their superannuation affairs before any consequences, such as a breach of their transfer balance cap, take effect. And from paragraph 38 of the same Law Companion guideline, to reduce your excess transfer balance so that you no longer exceed your transfer balance cap, you can choose to either commute fully or partially the death benefit income stream, or if you have one, a superannuation income stream you already have in the retirement phase. So your own income stream, and then you're receiving potentially another income stream if you anticipate that might happen. If you choose to commute your own superannuation income stream, the commuted amount can, if you choose, remain within the superannuation system as an accumulation phase interest, as distinct from, if you don't do that and you receive an income stream from a former partner, for example, and former being in the sense the person's died, then if that takes you over your transfer balance cap, because it will be aggregated with any existing pension amount, then what will happen is that amount of that pension you're supposedly in receipt of under the terms of a reversionary pension of some form, pension arrangement, reversionary or non-reversionary, then that must come out of the superannuation fund. So it must be paid out of the fund. Whereas if what you have done is commuted the pension that you have in your own member's interest prior to that time, and the receipt of the pension from your former partner or spouse, that will take your transfer balance cap, that can be applied to that, and if it's under $1.6 million, then you have the amount that you've commuted back into accumulation phase will continue to be in the superannuation system, and income will simply be taxed at 15% and capital gains at 10%. A very significant difference. But why I've just raised that in the context of paragraph 12, the Tax Office is saying, well, that's all fine. Paragraph 39. If, however, you choose to commute the death benefit income stream, the commuted amount cannot be retained as an accumulation phase interest, and the commuted amount must be paid out of the superannuation system to you as a death benefit superannuation lump sum. This is because the superannuation regulatory provisions require that death benefits are cashed out of the superannuation system as soon as practicable. Child death benefit pensions. The value of death benefit pensions paid to children is not applied to and does not affect their transfer balance cap later in life. Interesting concept, and something that we all need to think about with clients. The child caps operate differently depending on whether their parent has a transfer balance account at death if a deceased parent did not have a transfer balance account at date of death. So benefits are in accumulation phase, for example. The children may receive pension benefits up to the value of the transfer balance cap at that time, initially 1.6 million. If, that's not allowing for indexation, if a deceased parent had a transfer balance account, that is, they had started a pension during their life, the children can receive a proportionate share of their parents' benefits in the form of a pension. Children cannot receive any of their parents' accumulation benefits in the form of a pension. Now, when I say children here, I mean children who qualify and they need to be under the age of 25 years. There is no change to taxation of lump sum benefits on death. Therefore, for people who have attained 60 years, withdrawal of superannuation benefits by payment of a lump sum or prior to death will not result in any tax liability in respect of the payment. And of course, in respect of the payment and the withdrawal, we need to have satisfied a condition of release, which in the case for people over the age of 60, they need to have retired from a position. If superannuation benefits are not withdrawn prior to death and upon death are to be paid to a person who is not a dependent beneficiary of the deceased member, a tax liability will arise to the extent that the benefits paid are in excess of the amount of non-concessional superannuation contributions. Excepting for defined benefit pensions, as Phil mentioned this earlier, and market-linked pensions, the taxation of the withdrawal of superannuation benefits prior to death is not changed under the new law. For persons 60 years of age, documentation can be prepared, and we may have even talked about this in this forum before on a previous occasion, under which, upon receipt by the trustee of notification of withdrawal from the member themselves or by their attorney, the trustees will be declared to hold the assets of the fund as trustee for the member absolutely. Now, this actually brings into focus this planning to a greater extent than was even thought was necessary before. It's a very significant issue. 3, consequently, upon the death of the member, the assets of the fund held upon trust for the member absolutely will form part of the estate of the deceased member. If the person is over 60 years of age when this occurs, well, the funds will have come out of the superannuation fund without payment of any tax, simply form part of the person's estate, and then pass through the estate without payment of any tax to the end beneficiaries. Superannuation death benefits to superannuation rollover benefits. Well, look, what this slide simply confirms is that from 1 July 17, the rollover of a superannuation lump sum death benefit for dependent beneficiaries will be permitted. So we can roll from one fund to another fund. At the end of the day, as to whether the funds can remain in the fund or not will depend upon the particular age of the children as to whether they have to come out as a lump sum benefit or a pension benefit. What should members do now? And these are just some of the issues. Phil's raised more. And as I said from our meeting today, it's very illuminating to go through this process with clients, particularly those who have a few dollars in their super fund, that there is not one answer, and in fact, with a number of the substantial amount of the planning, it will only be in some years' time. Time will tell whether it was the right decision to make or not. There are risks in the decision making in the sense that what will happen to the value of assets and which assets have been selected, and whether a separate superannuation fund is established to take particular pension assets that it's anticipated will go up dramatically in value, and of course that doesn't count to the transfer balance cap, as Phil has mentioned. But there's a whole lot of planning issues with all of that need to be considered with clients. 1, review existing pension agreements and consider whether they should provide for a reversionary pension. Consider conversion of non-reversionary pensions to reversionary pensions. Consider reversionary pensions to minor children. Consider equalisation of spouses' member account balances and strategies for this to occur. We've got the point of superannuation contributions and the $500,000 issue in the future from an indexation. We've got the $1.6 million cap. We've got a whole lot of issues with regard to contributions. If spouses have both reached their transfer balance cap, consider locking in their respective death benefits. Where minor children may be involved, consider how flexibility in commutation and cashing of benefits is to be achieved. Consider potential liquidity issues for cashing of benefits. Consider resetting of cost basis of assets and choices, elections to be made under the segregated method and the proportionate method rules, and be concerned, as Mel said, with regard to Part 4A, potentially in relation to those issues and why it's being done. Review BDBNs for members 60 plus years. Consider having documentation prepared for withdrawal of superannuation benefits immediately prior to, and it is prior to, it's not somebody imagining they've signed documents after the event. Death for superannuation benefits to form part of the member's estate. Thanks very much, and I might just say thank you, Phil, you're doing that.